Hi, good morning, everyone. Thanks for joining us. We're still letting a few more folks in the room, but I think we're going to go ahead and start just because we only have an hour together. Thank you so much for joining this breakout session with us. In this session, we'll be talking about access to abortion and gender-affirming care and how the recent law changes around the country impact youth in foster care. It's sort of hard to follow our amazing main stage presentation, Cody and Madonna and Dr. Bridges, of course, but we're going to do the best we can to dig in a bit deeper into some of the key issues that came up in that session, and in particular, talk about what this means for youth in foster care, particularly those in California. We'll start with introductions. I'm Rebecca Gudeman, she, her, with the National Center for Youth Law. And I'm joined today by Luciana Spidler, who also uses she, her pronouns, and she's Director of Policy and Training at Children's Law Center. Please feel free to introduce yourself in the chat if you're so inclined, but no pressure. I will note that we are recording this session for posting on the platform later, so keep that in mind if you want to keep yourself anonymous during any discussion today. Next slide, please. So just to give you a sense of our flow today, we are going to start with some definitions just to make sure we're all at the same on the same ground floor. Then we'll review the national landscape of laws around abortion and gender-affirming care, hopefully taking what Dr. Bridges showed us a bit further. And after that, we'll turn to see what this means in California. We'll review the rights of youth in California, as well as what obligations the state has to support care and what that means for youth, both youth placed in California, but also California youth who are placed out of state. And then we'll close with some resources and hopefully time for discussion with all of you wise folks. Next slide, please. So a quick note on language, as was flagged at the beginning in our main stage. We believe that everyone deserves comprehensive and quality reproductive and sexual health care, and we do recognize that people of different gender identities can get pregnant. We will strive to use neutral language in this presentation, but as noted before, there may be times if we're talking about a specific law or research that we will use gendered language because that's what the law itself says. All right, so with that, we are going to jump into our definitions. So next slide, please. First, abortion. Abortion, in short, is termination of a pregnancy. And there's two types of abortions, a medication abortion and surgical abortion. Medication abortion is available through approximately the 11th week of pregnancy. A person selecting medication abortion will be prescribed 2 rounds of pills. And depending on state law, this may be something that can be prescribed using telehealth. And it could be medication that could be taken at home. And some people feel more comfortable with this choice, being able to have medication at home. But there also is surgical abortion, and availability of surgical abortion will depend on your clinic and your state. As noted by Dr. Bridges earlier, we started with Roe versus Wade defining abortion sort of by trimesters. And usually now what people look at is viability, which is around the 24th or 25th week of pregnancy. After viability, surgical abortion is typically limited to cases in which the life or health of the pregnant person is at grave risk. And it will ultimately depend on state law. Now, obviously, for both of these, the length of pregnancy is important. So as a reminder, the clock starts counting on pregnancy at the first day of a person's last period. So not surprisingly, most people will only discover they're pregnant when they miss that next period, which is often approximately 4 weeks after their last period. So at that point of that missed period, they're considered 4 weeks pregnant. And that becomes particularly relevant when we're looking at some of the laws that start to ban abortion at a certain week of pregnancy. All right, next slide, please. So before we define gender-affirming care, we thought it would be helpful to just cover a few basic terms. These definitions all come from Human Rights Watch, and you'll see the site below. So gender identity is one's inner sense of self, as male or female or both or neither, and your gender identity may align with or differ from the gender assigned at birth. Gender expression is how one presents themselves. It may be your clothing, your voice, your behavior. Your gender identity and your gender expression are different. For example, your gender identity may be that you identify as male, but you choose to wear what in US culture is considered traditionally female attire, for example, skirts or makeup. So your expression may vary from what our cultural definitions are, but your gender identity is different from that expression. Gender dysphoria is clinically significant distress when your birth gender does not align with your gender identity. Gender nonconformity is not the same as gender dysphoria. Gender nonconformity is the extent to which your identity or your expression differs from cultural norms. Dysphoria refers to the discomfort or distress caused by that discrepancy. So there's only some gender nonconforming people that experience gender dysphoria. It's not every person who experiences gender nonconformity experiences gender dysphoria. And this is important because the term gender dysphoria connects us to gender-affirming care. All right, next slide, please. So what is gender-affirming care? WHO, the World Health Organization, defines it as any single or combination of social, psychological, behavioral, or medical interventions designed to support and affirm gender identity. Examples include, but aren't limited to, counseling or social adaptations such as manipulation of clothing. This might mean breast binding or padding. It could be vocal coaching. It also could be hormones or surgery. Next slide, please. California law also defines gender-affirming care in statute, and this is a statute specifically related to the rights of foster youth. So this definition is found in Welfare and Institutions Code 16010.2, cited below. And so we're including it here because when we talk about the rights of youth to gender-affirming care, this is what our state defines in terms of what they have a right to. So gender-affirming healthcare means medically necessary healthcare that respects the gender identity of the patient as experienced and defined by the patient, and may include, but is not limited to, interventions to suppress the development of endogenous secondary sex characteristics, interventions to align the patient's appearance or physical body with the patient's gender identity, or interventions to alleviate symptoms of clinically significant distress resulting from gender dysphoria, as defined in the DSM. It also includes a definition of gender-affirming mental health care. So again, just keep this slide and keep this in mind when we talk about the rights of youth a little bit later today. All right, next slide, please. So as you can see, not all gender-affirming care is medical in nature. There's a range of medical services that are considered part of gender-affirming care as well. The World Professional Association for Transgender Health, WPATH, sets worldwide standards of care for medical interventions. And as part of those standards, they recommend care be provided in stages. So before any physical interventions are considered, they recommend extensive exploration of psychological, family, and social issues. And the duration of that exploration period may vary depending on the individual or the complexity of the situation. And then when it's after that, when it's time to explore physical interventions, WPATH recommends engaging in stages. So first psychological, then social transition, then what they call fully reversible interventions, and only after that, partially reversible, and then at the end, non-reversible interventions. An example of fully reversible intervention is a puberty suppressing hormone. So just as an example, WPATH standards for prescribing puberty suppressing hormones are that the adolescent must demonstrate long-lasting and intense pattern of gender dysphoria, that gender dysphoria has emerged or worsened with the onset of puberty. So it's important to note that this is about the onset of puberty, it's not before. That all relevant coexisting health concerns have been addressed, so we're taking into account whole health, and that the adolescent has given informed consent, and that the parent or caretaker or whoever is legally responsible for the young person has also consented and is involved in supporting the youth. So those are the criteria according to the WPATH standards of care. Next slide, please. So before we move ahead, we just want to include at the end of this a final definition. Abortion and gender-affirming care are an important focus right now. But when we say young people deserve and need good sexual and reproductive health, it's really important to remember that sexual and reproductive health is much more than just abortion or gender-affirming care. So here we have the definition from the United Nations. Good sexual and reproductive health is a state of complete physical, mental, and social well-being in all matters relating to the reproductive system. It implies people are able to have a satisfying and safe sex life, the capability to reproduce, and the freedom to decide if, when, and how often to do so. When we talk about healthy sexual development for young people, we believe sexual and reproductive health includes, but isn't limited to, ensuring access to comprehensive sexual health education, including information about healthy relationships and consent and puberty. It's about health promotion. It's about access to a full range of contraceptive options. It's about quality prenatal and postnatal care. It's about abortion. It's about STI prevention, services, and treatment, as well as gender-affirming care. And I'm sure you all could add much more to that list. So while we're focusing rightly on abortion and gender-affirming care today, we just don't want to forget that this is two components of a larger package of necessary care for young people. All right, next slide, please. So now what we want to do is just take some time to go over the legal landscape when it comes to abortion and gender-affirming care nationally. And now Dr. Bridges just spoke about Dobbs and about Roe, but we want to go ahead and review some of that quickly just to ground the rest of the conversation today. So next slide. So as Dr. Bridges noted, when we talk about Roe, really what Roe said was the government isn't going to interfere. And it's important to remember that when we're talking about abortion laws, there can be a range of laws that both make it more difficult to access abortion and laws that can actually help us support access to abortion. So when we think about laws that can make abortion more accessible, of course, we can start with a core right, but we can also think about all those barriers that we were talking about earlier and how to mitigate them. So that might include public funding, which, as was noted earlier, in most states is not available. It can be about laws that allow minors to consent to their own care, especially for those who can't or won't engage parents or guardians. Laws about confidentiality of health information. It also can be laws that help protect clinics to make providers and patients safe when they seek care. It can be about authorizing telehealth and addressing issues of transportation. It can be about making sure we have a diverse, educated medical workforce and not limiting delivery of care to just those with MDs. So there's a lot of different ways we can make abortion easier to access and make it more equitable. And there's many ways we can make it more difficult. So just keep that in mind as we move forward. Next slide, please. So we heard a little bit about Roe earlier. But just know that even before Roe, we had a panoply of laws in place in the different states that went from banning abortion to making abortion more accessible. And what Roe did is sort of set that ground floor for us. So in that 1973 opinion, the US Supreme Court found that there is this fundamental personal liberty. And so along with decisions related to marriage and contraception and education and family relationships, the court held the right to terminate a pregnancy is a fundamental right under the US Constitution. And that put that sort of bright red vertical line in that if we look at that black line as a spectrum of laws that from banning to addressing access, that bright red line was sort of you cannot cross these. And if any of your laws are, for example, absolutely banning abortion, then that would violate the Constitution. But as noted, the Supreme Court then evolved through various cases, evolved their thinking on this, and the standard really became that states could regulate abortion as long as their regulations didn't impose what they called an undue burden on abortion access. And many states did pass many such regulations. So some examples, even under Roe, that were considered legal, 27 states required a pregnant person to obtain and view an ultrasound of an embryo before getting an abortion. 24 states had that waiting period that Dr. Bridges mentioned. So that would mean the pregnant person had to come in for an appointment and then return 24 to 72 hours later for their procedure. Most states banned public health insurance from paying for abortion. 38 states require parental involvement, either parental consent or parental notification for minors, or in the alternative that the minor go to court to get a judge's order in order to access abortion. So even before Dobbs, even before Roe fell, it's really important to understand how these restrictions layered and impacted different people, because as we talked about so much earlier, that right to abortion was a right in name only for too many people, even before Roe went away. Next slide, please. So here's just two examples. When we think about some of the restrictions that were allowable, that states were allowed to pass even before Roe, one on its own may not cause an undue burden, but it's also really important to think about the layering effect that they could have. So here we see in Minnesota, they had a waiting period, they have public funding limits, and they had parental consent. In Texas, they had a waiting period, ultrasound required, telehealth ban, hospital clinic restrictions, public funding limits, parental consent, and more. And so when you think about sort of how these layer together, what it really meant is that the ability of a pregnant person to exercise their right often depended on their age, their access to money, to transportation, the flexibility of their work or school schedules, their access to family or social support, and their identities because of racism, homophobia, etc. And the truth is that at least 1 in 10 people seeking abortion, even before Dobbs, had to travel to another state for that care because of the restrictions that existed in their own state. So if we just think about youth in foster care, imagine you're a 17-year-old in foster care in California who just found out you're pregnant. Maybe you're in a pretty rural area and the nearest clinic only offers abortions in the mornings, a few days a week. It's 200 miles away. There's no public transportation and you don't have a car. And you're afraid to ask your foster caregiver or your group home for help because you're afraid of losing your placement. So for you, that 17-year-old in foster care, abortion is probably not going to be easy. And that's in California where there's no added state restrictions. Now imagine you're that 17-year-old, but you're in a state that has a waiting period requirement. So you need to find 2 rides to that clinic 200 miles away. Now imagine there's no public funding, or imagine there's a parental involvement law. And when you're in foster care, it becomes really complicated to think about who needs to get that notice or who needs to consent in order to access abortion. What does it even mean? In some states, it means the only way to access abortion would be through a court. So again, thinking about even before Dobbs, abortion really wasn't a viable option for a lot of people in this country and for a lot of young people in foster care. Next slide. And then, as we heard in the Dobbs case, the Supreme Court overturned Roe and decided that there's no constitutionally protected right to abortion. And that means it all goes back to the states. It goes back to what your state constitution says, what your state statutes say, and what case law says. As noted previously, there are states that have some affirming laws, and some states like California have moved to pass even more such protections since Dobbs last June. So let's start by looking at California. Next slide, please. So first, we want to flag in November, California voters passed Proposition 1. California's state constitution already protected abortion under its right to privacy, and the Supreme Court of California specifically ruled that this right extends to adolescents and would have covered youth in foster care. But Proposition 1 takes it further and affirms the state cannot interfere in an individual's reproductive freedom. So now this is an additional constitutionally protected right in the state of California. Next slide, please. But in addition, the legislature has passed several statutes that build on what already existed. I won't go through them all, and we've got some examples listed here, but just to flag, we've expanded the medical workforce who are eligible to provide abortion. We've increased protections for providers and clinics. We've passed laws to protect providers and patients from laws in other states. And over the last few years, as we'll talk about soon, we've clarified the rights to abortion and gender-affirming care for youth in foster care. Next slide, please. Okay, but now what about other states? Since June 2022, we've had some states pass abortion bans. About 13 have or have effectively banned abortion. Others have passed 16-week bans or 8-week bans, meaning that abortion is only available through the 8th week of pregnancy. And this is where it's important to remember we start that count on the day of the last period. So most people won't know they're pregnant until about week 4 at the earliest. And as previously discussed, many states already had laws on the books that regulated abortion and created those additional barriers. And those still stand as well. So you may be in a state like Georgia, which has a 6 to 8 week ban, but they still require parental notification or judicial bypass. And they also have a 24-hour waiting period. So if you find out you're pregnant right at 4 weeks and you're a minor in foster care, you have to consider the waiting period and judicial bypass and logistics to get to a clinic. So that when we're looking at the map that you see in front of you, you'll see that there are a range of sort of colors. When they flag some of the states as red, it either means that there's an outright ban, but they're also taking into account some of those additional layers that help make it more difficult to access abortion. I do want to note that there are about 10 states in which the state constitution protects the right to abortion. So even though the federal constitution would not limit that state from banning abortion, their state constitution does. Those states include Minnesota, California, Alaska, Montana, Iowa, New Mexico, New Jersey, Massachusetts, and Kansas. Now, they still may put in place state laws to sort of make it more difficult to access abortion, but they can't outright ban it. Now, what's also important to note is that these laws continue to change. The legislatures are all moving different bills forward. So if you're wondering about access in a particular state, it's really important to check this map in the moment. We put a link at the bottom of this slide, and we'll give it to you again later, but don't hold this map as sort of constant. You want to check it, and if you click the state in the map on the website, it will list for you all of the different laws that are currently in place, and that helps you understand why that state happens to be red or orange or blue or green. Okay, next slide, please. Now, when you are looking at those state laws, it's important to pay attention to the details. What do those laws do? Historically, laws focused on punishing or sort of making it more difficult to access abortion focused on the provider of care, and it was the state that moved to act. But things are changing. So some of the things to keep your eye out for are these criminal or civil laws. By criminal, we mean, would this be a misdemeanor or a felony if someone were to violate that law? would there possibly be criminal charges? Civil means there could be a hefty fine, but there's not a threat of jail. And as I said, are these statutes penalizing the provider, or are they penalizing the patient or others? Traditionally, the statutes that penalized abortion made it illegal to provide abortion, but it didn't target the patient themselves. But that is changing. We're also seeing different kinds of laws now. So just as a few examples, we do see laws that penalize performance of abortion, but we also see laws that penalize the pregnant person for a self-managed abortion, for example, taking medication. And now we're seeing laws that penalize what they're calling aiding and abetting of abortion. So that might implicate third parties who provide information or assist someone to access abortion in a state where that is illegal. There also are states that are exploring trying to make it illegal to help what they're calling transport minors. Now, we do have a constitutionally protected right to travel across state lines, but it does look a little bit different when we're talking about minors. And so if they try, what they do is they try to make it illegal to transport minors to facilitate engaging in illegal activities. Or support minors who are not, if you are someone other than the parent, in crossing state lines. So keep a good eye on what the laws are when you're looking at that map and sort of where they're going. Texas, everyone has heard about Texas SB 8. That was another sort of new angle on laws. And SB 8 allows anyone to file suit against someone who aids or abets an abortion. It's not a criminal statute. It's not one that the state sort of effectuates. It allows citizens to bring a civil suit and collect financial damages. And that's why it's being called a vigilante law, because it allows citizens to become the enforcers of law. And there are more and more states looking at passing similar statutes similar to that one in Texas. Let's see, was there anything? Yeah, I think I'll leave that there for now. And can we go to the next slide? I want to now switch to gender-affirming care. When it comes to gender-affirming care, it's really just important to remember that gender-affirming care is recognized as a standard of care by all major medical organizations. But we have seen a host of statutes, regulations, and bills popping up designed to limit access these days. Next slide. Oh, here we are. Sorry, could you go back? So again, just like I was talking about, when we look at these bills and statutes, it's really important to look at exactly what they're doing. So for example, what is it, if we say it's banning gender-affirming care, what is it banning exactly? Is it banning provision of hormones? Is it banning surgery? Is it an age-related ban? Is it a ban on public funding? Also take a look to see if it's a criminal or civil. We won't show these today, but just to flag that there are more and more bills popping up related to gender identity in schools, that require, for example, schools to report to parents if a young person is attempting to use different gender identifying pronouns. There's more laws popping up restricting participation in sports related to gender. So we won't cover those because it's not about medical care, but just as we talked about layering effect of laws with abortion, those kinds of laws also create a layering effect that makes it more difficult to access healthcare. All right, next slide, please. So here's a map of gender-affirming care bans. So far, you'll see there's only 4 states that are sort of lit up with having outright bans, but I say only in quotes because it's important to flag there's a couple states with laws currently in litigation. So there's a stay on implementation, but we need to keep our eye on them. And then there's states like Texas and Oklahoma, in which state executives have attempted to restrict access in other ways. So it's not a state law, but they've tried to impose bans via other mechanisms. And there's bills moving in many states. Again, as noted on the slide before, it's really important to know exactly what these statutes say. So in Arizona, the law bans surgical care for minors, but not hormone care. This is important because if you remember the standards we reviewed before, the first steps in gender-affirming care are psychological and social, followed by fully reversible puberty suppressors, which are hormones, followed by partially reversible hormone supplements. And surgery is the last step, and most types of surgery really aren't available or recommended for minors. Alabama bans hormone treatment, though that law is temporarily blocked in court. That's another state that requires schools to inform parents if a child expresses thoughts that might label them as transgender. Arkansas also has a law that's blocked in court. Tennessee blocks hormone treatment for quote unquote pre-pubertal teens. Now, again, best practice says hormones would only begin at puberty. So while this is a ban, it's not flagged on the map in the same way because it conflicts with medical standards. So it just highlights the lack of knowledge that some of our legislatures have when they're trying to pass some of these laws. Texas, I'm sure folks have heard about the Texas situation. In Texas, their attorney general issued a non-binding opinion that defines gender-affirming care as child abuse that would require reporting by mandated reporters. This went to court. It's not binding, but it has still led to some investigations of families who have kids who have been getting gender-affirming care, and it's led to reports, and it's led to some folks being afraid to seek care because there's confusion about what this interpretation means. Utah just banned hormone treatment for minors. There are exceptions for those who began treatment before the law was passed, and this was just this last month. And this is, next slide, please. So the previous map, like I said, may not have looked so bad, but this could change quickly. There are many states considering bills in 2023 that target gender-affirming care. For example, Missouri has a bill that would ban gender-affirming care, whatever type, for minors entirely. It's similar to the law in Arkansas that's currently held up in court. Another bill targets health providers who willingly and knowingly provide gender-affirming care. Some bills target services for minors under age 18, and some bills, like one in Oklahoma and South Carolina right now, would ban gender-affirming care for anyone up to age 21. So really important also to keep your eye on the map and make sure you're up to date on what's going on. Next slide, please. But just like abortion, there are some states that are passing statutes to ensure access to necessary care. California is one, and I'll use that as an example, but it's not the only one. But just using California as an example, we have public funding for qualifying gender-affirming care through our Medicaid program. California recently passed SB 923, the Transgender Inclusive Care Act. It requires physician continuing medical education about best practices in delivering gender-affirming care. It asks the California Department of Health and Human Services to issue enforceable quality of care standards for transgender care. It requires health plans to provide a list of in-network providers to those who are insured by them, and it creates some oversight agencies to track complaints and basically just try to ensure that we've created a level and standard of care in our state for transgender and gender-affirming care services. California also passed in 2022 a law, SB 109, that will protect youth and their families who travel to California for gender-affirming care. So, for example, if a family in Utah brings their child to California to continue to receive gender-affirming care, they'd be protected should Utah attempt to bring charges against them or remove their kid from parental custody. And there are several other, and there are several bills moving forward this year that would continue these protections, such as SB 36, which would protect people in California from arrest warrants from other states based on accusations or convictions of abortion or gender-affirming care laws. And like I said, California is not alone. Illinois has been moving and recently passed some laws that look very similar to the ones that on this slide. So keep your eye on the chart and the map for up-to-date sort of what is the status of law in each state. Okay, so that is where we are sort of nationally, but now I'm going to pass it to Luciana to talk about what this means for youth in foster care in California.
Thank you, Rebecca. Good morning, everyone. So I'm looking at the time. We don't have a ton of time. This could have been like a 2-3 hour presentation. So I am going to try and get through the information. You all have access to the slide deck if there's anything you want to go back to. But up to now, we heard a really good background on just abortion and gender-affirming care, status of the law now in California, as well as the rest of the country. I want to focus us a little more on how this affects foster youth. Let's see. So just in general, when a child goes into foster care, the state assumes an obligation to provide medical care for that youth. And categorically, all foster youth are eligible for Medicaid. So we know that as a basis, but that doesn't give us too much information about sexual and reproductive health. So in order to find out what is happening within each state, I was going to say country, it's important to really dig into the state, the particular state's constitution, state law, and then also any agency policies and practices that might clarify or set expectations and duties. You would not be surprised to know that there's not oftentimes, most of the time, medical care and healthcare is stated somewhere in the law, but and it's spelled out pretty clearly. But when it comes to sexual and reproductive health, that is not as common to have really detailed information, laws, and policies. So you have to start looking at different things that would affect access to sexual reproductive health care, including looking at the states, how they're defining health care, what is necessary care in that particular state, whether the state has, for foster youth, minors' right to consent and minors' right to confidentiality. You can look at pregnant people's right to care. And all those answers will help you define a little of what the sexual and reproductive health laws and statuses in that particular state. Another thing it's important to look into is what is the agency's duty? Is it spelled out? Like, do the social workers have a requirement to provide services or support? What are they required to do? Some states, for example, the agency or social worker is not able to assist, facilitate, or even consent to some of this care, as well as caregivers. There's a restriction on caregivers in some states. So those are all things to start to dig into within the laws and the Constitution and the policies. So that's how you would look at it just at a national level. I'm going to focus on California and California foster youth as it relates to their sexual and reproductive health care rights. You would not be surprised to know that California, just like every other state, did not have very specific or spelled out laws and policies related to sexual and reproductive health. About 6 years ago, when we started to do this work, when REP, which is the organization that's putting on the conference, and REP is comprised of different organizations, advocacy organizations, including National Center for Youth Law, whom Rebecca works with, and Children's Law Center. We got together about 6 years ago and realized that these laws are not really spelled out. And at the same time, we were seeing a lot of violations of laws and policies from our end as children's attorneys and children's law center, children being denied their rights, having contraception being confiscated, people having caregivers having them sign celibacy plans. So all these different areas in which their rights were being violated. So the group of organizations got together and started working on laws and policies. We worked very closely with the California Department of Social Services to help to develop policies that really spell out what the rights of youth are and what are the duties of case workers, social workers, probation officers, as well as caregivers. So what I'm going to read to you now is some rights of youth, foster youth in California. These rights that I'm going to read come from the Foster Youth Bill of Rights. So they've been included in the Foster Youth Bill of Rights, and the code section is referenced underneath each slide. But these laws come from different areas. They come from the Constitution. They come from different code sections. 6 years later, we've been able to add all this stuff to the Foster Youth Bill of Rights, making it a little more concise and easier to look at and find the rights very clearly defined. So California foster youth have a right to access age-appropriate, medically accurate information about reproductive health care, the prevention of unplanned pregnancies, and the prevention and treatment of sexually transmitted infections. At any age, they're able to consent to or decline services regarding contraception, pregnancy care, prenatal care, and so forth. So that means that at any age, they can say, yes, I would like these services. Yes, I would like contraception or an abortion. They can also say, no, I do not wish to go forward with whatever services they're providing. At age 12 years or older, they can choose whenever possible a healthcare provider of their choice. That's of course with the caveat that it's covered under federal Medicaid or other approved insurance. California has state funds that pays for a lot of the repro health services, if not all. So again, allowing foster youth to go to a provider of their choice, to have access and receive reproductive and sexual health care with reasonable promptness that meets the needs of the child. We know that a lot of these services are time sensitive. So in the Foster Youth Bill of Rights, it's very clear that those services have to be provided in a timely manner. And that they should participate in the decision-making regarding these treatments and services. And just as a caveat, these rights also include gender-affirming healthcare and gender-affirming mental health care. That is also clear in the Foster Youth Bill of Rights. And finally, foster youth have the right to confidentiality of medical and mental health records, including but not limited to HIV status, substance use disorder history and treatment, and sexual and reproductive health care. So this is really important because we know, especially in today's landscape, having that ability to get treatment confidentially and not having it be disclosed allows for more youth to actually access and seek these services. So I quickly went over the rights, and I just want to mention that those are some rights that we included. There's a whole list of rights that would be very applicable to this area, including right to transportation and other such things. So definitely worth looking at the sites that we were citing under each slide. But as you can tell, California has a really wide spectrum of rights available to foster youth. But rights are only as good as whether the youth can access them or not. So it's also at the same time really important to know who is responsible, whose duty is it to ensure the foster youth are able to access the services that they're entitled to, the services and treatment and information. So California also did not have very specific list of duties of social workers or caregivers for quite a while. When we started doing this work, it was pretty unclear who was responsible for doing what. And again, this is something that the advocates worked very closely with the state of California, the Department of Social Services, and helped to develop materials that really set forth the obligations of the caseworker, which includes, again, social worker and probation officers. Also lists best practices in this area for caseworkers as well as caregivers. So some obligations that are listed in the materials that have been issued by the California Department of Social Services are the duty to confirm that the youth has received comprehensive sex ed in middle school and in high school, that they had a conversation with the youth annually. So social workers have to annually speak with youth who are ages 10 and over and let them know about their right to medically accurate and age-appropriate information, their right to consent and confidentiality rights, and how to access sexual and reproductive health care. Again, these are all rights that the youth have, but if they don't know they have the right, it is very hard for them to actually act on those rights. The social workers are required to inform them. They also have to facilitate access to care, and that includes removing any barriers. So if there's something getting in the way from them getting care, it is the duty of the caseworker to remove that barrier. So for example, one of the biggest barriers we see for foster youth is transportation. You may know that you have a right to receive contraception of your choice and to go to a provider of your choice, but guess what? Maybe you're in a group home and you don't have anyone to take you to Planned Parenthood. So they are required to assist with removing that barrier of transportation and providing transportation to the services. Case managers also have to document conversations that they've had with their youth in a case plan and court report. This is to ensure that that it's happening and to have some oversight of conversations and rights being provided to youth. And caseworkers have to receive mandatory training on all this. So as the training has been coming into play in the last years, it's become law. We have more and more caseworkers being informed of their duties, of the rights of youth, and obliging with all these duties. Really quickly, additional obligations include that CDSS, the Department of Social Services, has to develop guidance and best practices. The social worker is responsible for ensuring that youth have access to gender-affirming care provided by experienced, qualified, and licensed clinicians. CDSS has to develop screening tools to identify appropriate providers for gender-affirming care. And they have to ensure placements consider and honor gender identity and placement with caregivers who have been trained on serving LGBTQ youth. And finally, and a very important duty is that they must honor the confidentiality of the youth when filling out case plans, court reports. So those are rights and duties within California. So I want to turn now to the question about what about California foster youth who are living out of state. So, you know, when the Dobbs decision came down and everybody was worried about abortion access out of state, as attorneys who represent California foster youth, we in-house began to worry and think about what happens to our clients who are placed out of state, who are living out of state, who are maybe with a relative out of state, who are going to college out of state in a dorm. What if they need services that are no longer going to be legal or available? So because of all the work that the organizations, the advocates had been doing with the California Department of Social Services in the last 6 years, it was just a wonderful collaboration where we raised the issue. And very quickly, CDSS was able to issue guidance, which I believe it's been about a month now. So right at the beginning of the year, they were able to issue guidance answering the question, what about California foster youth who are living out of state? So the guidance is listed at the bottom of this slide. I encourage you to look it up because it's very detailed with really good information. But the most important, I think the most helpful quote out of this whole guidance, and I'll read it to you, is for any California foster youth placed in a state that has limited or banned the provisions of any services related to sexual, reproductive, or gender-affirming healthcare, the county case managers are to continue to ensure that these youth are able to receive healthcare services as required under California law. So they've answered the question and made it very clear. Our California foster youth living out of state are still able to access their rights under California law. And I'm going to check the time right now. I do want to leave some time for question and answers. So we did include some other, there's just really wonderful guidance within that, what's called an ACIN. But I encourage you to look it up. And I am happy to put on the chat the website of it. But it has great guidance about what to do when a youth is out of state, how to provide assistance, and very importantly, how to think about whether or not a youth should choose to live out of state if there's a choice, obviously, and looking into the laws of other states. So how can we support foster youth in receiving services? Anyone, as you know, whether it's a CASA, a caregiver, a social worker, an attorney. The number one most important thing in this day and time is be mindful of confidentiality in conversations and social media. Everything is out there these days, and we know that laws are changing, as Rebecca mentioned, throughout the country. So it is very important that we're mindful of confidentiality and what we post and reveal. We want to make sure that youth have contact information for their attorney, and refer the youth to their attorney if they need support. And I'll tell you shortly why it's so important to connect them to an attorney, where in the past it might have been sufficient to just work with other supports. If possible, it's good to be aware of local resources in the placement state, and I do have a slide on some resources available, what services are available, both healthcare, mental health, and funding for services, and be aware of national helpline resources. Again, I will show you a slide that with some helpful information. We do want to put a caveat, and you know, Rebecca mentioned there's laws that are being proposed throughout the country, and we don't know what the landscape of things are going to look like, right? We don't know what kind of laws are going to pass and how they're going to be enforced. For example, there's some states who are trying to make it illegal to quote unquote aid and abet an abortion. And how they define aiding and abetting, it could be different from state to state, but it could be as simple as having someone share information about where to get an abortion, how to get an abortion, how to access an abortion. So we want to be mindful of these laws when you're assisting youth, which is one of the reasons why I say it's really helpful at this point to connect the youth to an attorney, to their attorney, and to refer to some of the legal guidance, because again, we don't know, it's going to vary state by state, and it's ever changing and evolving. So as I mentioned, that the dependency attorney is super important at this stage. Fortunately, in California, unlike all states, California foster youth get assigned an attorney, get appointed an attorney to represent them. Within their relationship, there's attorney-client privilege. So the attorney is able to keep confidentially any information that they share with each other. Attorneys also have the right to review medical information without breaching HIPAA laws. And they also have the ability to evaluate the legal landscape, like what are the laws where they are, what are the implications of receiving the services or receiving assistance for their services. So it's very important at this point to try and connect the youth to their dependency attorney. And again, this is also guidance that has been supported and issued by the California Department of Social Services in their guidance that I mentioned earlier. I'm just going to check on the time. Yes, we're very close to time. So this is the resource page that I mentioned earlier with some really helpful information. I encourage you to take a look and play around with it so you know what information's out there when it does become needed. You don't want to be, and we have started to get calls at our office from clients who are out of state and being in the crunch time, figuring out where to get assistance. Really quickly on how to support youth living in California. Now, I've gone over, California has some amazing rights just in general about abortion and gender-affirming care and for foster youth. But I don't want to undermine the importance of foster youth in California. Getting access to services has not always been easy. Even with the great laws that we have and the obligations of social workers, we still have a problem accessing care. And the foster youth do encounter much bigger barriers than other youth in the general population. So it's still important to be able to assist youth to remove those barriers. One website that I wanted to point out is the California Abortion Access. If you need to know where you can get an abortion close by, this is super helpful. And the other very important thing to note is we have been getting clinics popping up throughout California that look just like Planned Parenthoods and other clinics that provide a full scope of care, but don't necessarily provide a full scope of care. They're called crisis pregnancy centers, and there's actually a session on this today, which I'm a little bummed we can't observe because it's at the same time, but they have some wonderful information. These crisis pregnancy centers do not offer the full scope of care to our clients. So just be aware that they're there, that they exist, that oftentimes it's very hard to tell them apart. But some questions you can ask if you want to do some background research before you refer a youth to a clinic or you accompany a youth to a clinic. Here's some really helpful questions to help you determine what kind of clinic it is, what kind of services they provide, and whether or not the youth is really going to be able to receive the care that they wish to receive. I am gonna end right there. I know I kind of rushed through my slides, but I wanted to make sure to leave a little room for questions and answers. All of the slides have sources listed in them, so you are able to go back and look up anything that we might have skipped. And our email addresses are on the slide if you have any follow-up questions. I know Rebecca and I would be happy to continue the conversation offline.
And I'll just note that the Q&A for this session will remain open for the rest of the day. So even though we've run out of time, if you have questions that we haven't been able to answer, please feel free to add them there. And Luciana and I will go back. And if others have responses they want to add in as well, we're happy to do that. And I've been trying to answer some questions in the chat so far, both in the Zoom and on the Whova website. But if you have any more questions, please feel free. Well, I guess we've run out of time now, so please feel free to add them to the Q&A in the Whova, and we will continue to respond to them. Thank you so much for joining us, and enjoy the rest of the conference, everyone.
Thank you, everyone.
Right. Bye.
Thank you, everyone.